Welcome to the Influential Personal Brand Podcast. This is the place where we help mission-driven messengers just like you learn how to build and monetize your personal brand. My name is Rory Vaden, and I'm the co-founder of Brand Builders Group, a Hall of Fame speaker, and New York Times bestselling author. And this show is to help experts learn how to become more wealthy and well-known. I know you're going to love it. Thanks for being here. Let's get started.
Hey, everybody, and welcome to the Influential Personal Brand Podcast. So excited to get to interview a newer friend of mine, Autumn Witt Boyd. And although we are just getting to know each other over the last several months, we actually have a long history in common that we discovered at a Christmas party where her husband and I grew up in the same hometown, which Dalton, Georgia is a pretty small hometown.
Very small.
So, and then you live in the same city as my brothers. And so there's so many cool connections, and I love to get to interview people that I also have personal connections with. But before I formally introduce you guys to Autumn, I want to tell you what this episode is going to be about and why you should probably stick around. Today, we're going to be talking about how to protect your brand. And we mean in the legal sense. So we're going to be talking about different things you need to know in terms of maybe trademarks, copyrights, just intellectual property in general. But then also it's in the litigious environment that we tend to live in here in the United States of America. What do you need to know that you don't know? And so again, this is kind of one of those episodes that doesn't matter where you're at in your journey. This is going to be helpful for you. It does not matter if you are a beginner or you are super established. I promise you, there is something that you're like, oh, I'm so glad I listened today. I had no idea. So this is one of those episodes you want to stick around for. So let me formally introduce you to Miss Autumn Witt Boyd. So Autumn is the founder and owner of AWB Law Firm, which in my opinion is really a law firm really built for personal brands. Now, I'll let you define that in a second, but I think that's really important because I think that you have created a really unique niche in the market that you cater to the individual, the solopreneur, the entrepreneur, the small business owner who also has some sort of, personal brand as a part of their business, and anything from contract templates to custom built contracts to just even strategy on your IP, which is one of the things we're going to talk about today. This is a really unique business model that you have created to cater to people like me and everyone listening today. So to help them get to know you a little bit, I would love to hear from you. How did you create this niche in the marketplace? Because it is different than most other attorneys and other firms that we have met, that we have talked to over the years, because you have a deep knowledge in the personal brand space. So how did that happen?
Absolutely by accident. It was not a grand plan. I quit my last job. Hopefully we'll never have another one, and started this firm in 2015. And I tried a couple different things. I tried working with startups. I tried working with more creative entrepreneurs, service providers. And what I found as I tried lots of different things was that my favorite people to work with were these personal brands, mostly folks selling either education products, doing speaking, a lot of coaches. So all of them had a deep mission at the kind of core of their business. So they wanted to build something bigger than themselves. They wanted to have an impact. And they were just energetic and creative and fun to work with. My background was as a copyright litigator. So I used to go to court and mostly worked with photographers and stock photo agencies. So I have a deep knowledge of copyright. And what I found was for these personal brands, I ended up building a team that we can really do everything they need. The good news is the business model is fairly simple, even as it scales. Now, as it scales, the complexity of some of the legal needs becomes more significant. But, in the beginning, there's not a lot of revenue streams. There's not a lot of moving parts and pieces. So it's easy for us to come in and really make a big impact with not a huge amount of, legal spend or a lot of, complex legal protections.
Yeah, so that's a great opening to this conversation. And I love that you went to, you were in litigation for different copyright.
Yeah.
That's one of the biggest things that I think our audience is just unaware about. And I think it's because it's one of those things where there's just a lot of nuance to what can you copyright? What do you trademark? But what should you copyright
Yes.
or what should you trademark? So can you just like define it? Like, what's the difference between a copyright and a trademark?
Yes. So we'll dig in. So when we think about copyrights, think about content. So if you have a curriculum or a framework, things that you teach, a signature talk that you give, all of that is going to be protected by copyright. Also, things that you think of more as like true art. So photos, sculptures, paintings, movies, music, all of that is covered by copyright. When we think about a trademark, think about a brand. So it could be your name if you are the personal brand. We certainly have helped some of our clients register their names as trademarks. Often it is the name of a signature concept, or it could be the name of a business. If you have a signature course or offering, it could be that name. It could be a podcast name. Anything you think of that is attached to your company. So the purpose of a trademark is to help customers find you, basically, and to know that when they find you, you are the thing they were looking for. So in a more traditional corporate sense, think of like Coca-Cola or McDonald's. Like those are big, big brand names. So you know when you get a Coke off the shelf, you know what you're getting because it has that Coke branding on it.
Oh, that's a really great distinguishing factor. And I love how simple that is. It's just like copyright is content, right?
Yeah.
And I think, and I love too, it's like, it's art is considered into like photos and anything like that, but it's the creation, right? So it's what have
Yeah.
you created, whereas trademarks or anything associated with a brand. So your name, company name, curriculum names, so titles, and
Yeah.
ultimately helping define that you are who you say you are and helping other people find you.
Yeah. There's a little bit of overlap when it comes to logos. So think of like Mickey Mouse is my favorite example here. You know, that is a creative work, but it also signifies the Walt Disney brand. But for most of the people in our space, you're not really going to have a lot of overlap. Logos are usually pretty simple.
So it's interesting. So then with all of the people that you have worked with, like what do you think people should be like in our space, right? So most of the people listening to this are in some sort of content creation world, whether it's you're writing books or creating speeches, or you have coaching programs, consulting programs, or you're just trying to come up with methodologies and frameworks for your existing business, right? So what should we be thinking about when it comes to, well, what should I go and get, a trademark for? What should I try to get a copyright for?
Yeah. And I forgot to give my standard disclaimer, AJ, which is I am a lawyer, but this is not legal advice. So I'll plug that in. And I'm a bit of a contrarian when it comes to trademarks. So I really think for personal brands, the folks who are listening probably don't need a lot of registered trademarks in their business. So what we usually recommend, we'll kind of take an inventory when we start working with a new client. What are the different brands you're using in your business? And we'll look at them and we try to prioritize what is making you money, what is attached to something, so that it's really a business asset. Because a lot of our clients may have 10 or 15 different brands in their business. They may have slogans or things they say a lot. They may have, various different offerings, but usually there's one or two that bubble to the top of like, oh, if someone copied this, it would really confuse my audience, or like I would definitely lose sales. So we kind of prioritize it that way. Is it making you money? Number two, are you going to stick with it for a while? Because in the United States, the trademark registration process is expensive and it takes forever. So right now, best case scenario is about a year from the day we file an application to the day it's approved by the USPTO. That is not us being slow. That is, they are overwhelmed and understaffed, and it's just very slow. So we're big on ROI here at our firm. I am never asking people to spend money on a legal protection that's not really going to do something to benefit their business. So I want to make sure that you're going to stick with it long enough that waiting that time, spending a couple $1,000s, usually if you're working with a lawyer on a trademark registration, it's not cheap. And you want to do it the right way. It's very easy to mess up on your own. So I want to make sure you're going to stick with it long enough to see some benefit from having that R in a circle. And then the last thing I always ask is, would you be upset if it were copied? So sometimes there are things that aren't necessarily a moneymaker, but they're just very personal, or you feel really attached to them. And so maybe it is, if you do have the extra funds in your business, it may make sense to register that, just because you would feel very violated if someone else copied it.
Mm.
And what a trademark registration does for you, it gives you an easier way to enforce your rights. So if you're not willing to send a cease and desist letter, if you don't want to kind of become a little bit combative, now you don't have to file a lawsuit, but to maintain a trademark registration, you have to enforce it. That's one of the requirements, or it will just basically become worthless. So you have to be monitoring the marketplace, seeing if anybody else out there is starting something similar. You got to keep your eyes out. And we do that for a lot of our clients. And then, take appropriate action. So send a cease and desist letter, or try and figure out, can we coexist in this marketplace? Can you stay in your lane and I'll stay in my lane? So getting the registration is really just step one of a much longer process of protecting that brand.
Yeah, so that's a really good conversation. So registration is step one, because you may not even get it, right? You may apply for it and be denied, but assuming you do get it, that's really step one, because then you have to have things in place to monitor the marketplace to see if anyone else is using it. And then you actually have to be willing, right, both in emotion and in dollars, to actually enforce it. So, and I love those questions you said. It's like, hey, is it making you money? Are you going to stick with it? And would you be upset if somebody else was using it? And if the answer is yes to all of this, it's going to be a couple $1,000s and a year. And that's
or more. It could be 2 or 3 years, depending on kind of some of the speed bumps that you may come across. Yeah.
But they approve based on date of application, date of when it was in use. How does that work?
So there's 2 ways you can file an application in the United States. One is you're actually using the trademark. So that's called an in-use application. Those go the fastest. But you can also file an application if you've got an idea or something you're planning to launch in the near future, and that's called intent to use. So you go through the process and then you kind of hit a speed bump, and you still do have to show you're using it. So you can't get to the finish line, but it will put you ahead of the line of somebody who comes after you to try and apply. But in the US, the rights are all based on use. So we have what's called a race system. So it's a race to be the first to actually use your trademark in connection with selling something. So it's not enough to just have a landing page up or a coming soon. You have to actually be using it in commerce.
Yeah, so
it can get tricky.
This is so interesting. So I have a question. So what about, because you mentioned slogans, but like, what about quotes?
Mm-hmm.
Like, is that a thing that people trademark?
It can be, if it's something. Now, it has to be used in commerce, and you have to prove that to the US Patent and Trademark Office. And they have specific ways they want to see you using it. So it has to be used kind of near where you're selling something. So you'd have to use it on a sales page, or in a brochure that has a way that you can call and buy something. There's different ways, but they're always looking for you to use it in like an advertising or marketing way. It can't just be, I say this thing on my podcast a lot.
What if it was something
what
if it was something in your book?
Yeah. So you'd have to show that you're using that quote, not just in the book. It would have to be featured in, again, like a pull quote on a sales page or something. Yeah.
Interesting.
It's very strict. They're very stringent. This is why a lot of applications get denied. And that's why I always say you want to work with a trademark lawyer who knows what they're doing.
To have it in the right and necessary places. But really, they want to see it. How is it being used for commerce?
Yeah, exactly. That's what trademarks are all about. Copyright, it could absolutely be in the book and be protected, but it has to be, a quote would be too short to be protected by copyright. It has to be considered a work.
Fascinating.
Does that make sense? Yeah.
So what do you see are the biggest mistakes that people are making when it comes to copyright and trademark?
So on the trademark side, since we've been talking about that, the biggest one is choosing a brand and then not checking to see if anyone else is already using it. Because again, we're a race system. So if somebody else, you come up with this really great slogan or brand idea, someone else is already using it. It doesn't matter if they stay very tiny and you achieve this great success and huge exposure, they would still have what's called priority. So they win the race. They could come after you, years later, after you've really built that brand, invested time and money into promoting it. So we always want to start with a nice, fresh, clean brand that is really just yours, that you can own.
Agreed. So what should people be doing to go, oh, shoot, is my stuff already being used out there? Like, where's like the safest place to check? How would we do that?
Yeah. So I usually recommend a couple. You can do these on your own. Now we have a paid tool that we use at the law firm. So if you want to register your trademark, we'll do a deeper search, but you can absolutely do it on your own. I always start with a Google, but go to like page 5 or 6, like do a deep Google. Check any social media platforms that you may be using. So if you plan to be on LinkedIn, go check LinkedIn and see if that brand pops up when you search. Same if you intend to start a podcast, go check the podcast players, type in the brand, see what pops up. And then also the US Patent and Trademark Office, but there are so many unregistered marks that could still cause you problems because in the US, you can have what's called common law rights, even if you never register your trademark.
What's that?
So you can file a lawsuit. You can take action to protect your brand, even if it's not registered. It's a state law right. So it's not quite as strong as, the federal rights that you get when you register your trademark. There's definitely advantages to registering. But there are people out there with common law rights that can cause you problems. So again, that's why we want to make sure we search and we see it's not just the registered ones that could cause us problems.
Yeah. So back to this litigious environment where anyone can file a lawsuit for anything, for any reason.
Correct.
Yeah. Thanks, Americans. That is definitely something to be on the lookout for.
Pros and cons for sure. Yeah.
And I love that. It's like do a Google search, go through podcasts, right? Search, Apple, iTunes, clearly the US Patent and Trademark Office, social media platforms. What about Amazon? Like, should we be searching like Amazon for book titles, or does that really matter?
So a single book title is never a trademark.
Okay.
But if you're doing a series of books, that can, because book titles are generally, not really a brand when you think about if you're looking for something.
Sure.
Yeah. But if you have a book and a course that goes with it, or if you have a book and, a workbook or a series of things, that can't. Now there is confusion among book titles, but I mean, I'm sure you've noticed if you search up a book title, there may be 5 different books with the same title. That's pretty frequent.
Yes. Or
so
just
I
like
usually
one word different. Yes.
Yeah. I usually don't worry too much about that if the plan is just to make it a book. Now, if you're planning on making it a big brand, you may want to consider choosing a different title because you don't want that confusion.
So I want to be clear really quickly. So using my husband as an example, who has his first book, Take the Stairs, which was a New York Times best-selling book. So you're telling me right now, if some other person today decided they wanted to write a book called Take the Stairs, they could, and it's not a big,
it's not a violation of any rights. Yes, I know.
But
authors don't like that.
But it's good to know. But we would also have this common law right where we could go, hey, and potentially win something, or no?
Not for a book title. Book titles are generally never a trade. But if he has other things connected to it, that could become a brand. Like, does he have a signature talk or like handouts or so usually there's like a universe that grows around something when it's a slash like that.
But I think this is a really unique and important topic for
the
our
brain bender for sure, right?
For this, because it's like if you're going to write a book and have a book title, then you also need to have a keynote for sure. But
or
if
at
you
least like a freebie, and a lot of people do this in publishing now. You buy the book early, you get some sort of online resource. Yeah, I know you're very familiar with that, AJ.
And that's why I'm asking, because I just like, out of all the things, like this is something, it's like, hey, it's like if you're going to write a book, then you need to make sure you have, the coordinated keynote speech to it. You want to have some sort of like, hey, free download that you can get ahead, and they all need to have the same title. And then in that regard, if you had
it's a brand.
Now it's a brand. So now we can go and try to trademark it.
Yes, exactly. Yep.
Y'all,
and this is always something, and this is always something I negotiate when my clients get book deals, is making sure that they own the trademark to the title, because that is not something that most publishing companies think about.
Yeah, but that is a huge deal.
It's a valuable asset for sure.
Yeah, if you're going to publish this book, then we need you to at least publish this free workbook that's 3 pages that goes with it, and have your keynote title the same thing. Now we have a brand. Now we can go trademark it. And that's a really
and now you can
thing.
Exclude other people. Yeah.
That's so nuanced, but so vitally valuable for every single person who has listened to this, who goes, one day I want to write a book. Because we do this thing So we have what we call the 5 title tests. And a part of those tests is one of them is the availability test. It's like,
I like it.
is it already in use? Right.
Yeah.
But what your kid is like, we actually tell people, which now I need to be really on top of like how we're explaining this, because we actually say, hey, if it's already a pretty well like best-selling book on Amazon, like
I agree. I would avoid it. Yeah.
find a new title. But ultimately, if it's just that, somebody else could go, nah, I'm going to go for it. I'm taking it.
It's true. Yeah. If you're really
Wow.
connected to it. Yeah.
But that's a big deal. You
Yeah.
know, our whole thing is like, hey, if it's already taken, let's find something that can be unique.
No, I agree. I agree for
But
sure.
somebody could on their own go, wow, they don't even have a website. They don't have a podcast. They don't have a thing. They don't have anything else. I'm going for it and I'm going to take it. That's no joke. I mean, that's kind of a big deal.
Yeah.
Everyone, back to why everyone needs to listen to this episode. It's kind of a big deal. Now I know that we've been like specifically talking about like copyrights and trademarks, and that's a teeny tiny part of what we really need to know to protect our brands. And so on this whole idea of making sure things aren't being copied, what should we know? What do we need to know in order to protect our website, content, products, services? Like what else do we need to know?
Yeah. So when we think about most of those things, they're going to be protected by copyright, not trademark. And we've all probably heard you have automatic copyright protection as soon as you create a work. If you haven't, good news, you have automatic copyright protection as soon as it's out of your brain. It has to be in a computer document or written or something. But in the United States, you cannot file a lawsuit until it's registered. So it's kind of the opposite of with trademark. You don't have those common law rights. So if you have something, again, that's a really key asset in the business, a signature course, a signature talk, something that would really have an impact if someone copied it, we highly recommend registering that with the US Copyright Office. And it doesn't mean you're ever going to file a lawsuit, but if you did have to send that cease and desist letter, if I get a cease and desist letter and I check and it's not registered, I'm like, I'm not really worried about it because I know they can't really do anything. It's kind of an empty threat.
Yeah,
so
that's interesting.
The good news is the copyright process is much simpler than the trademark process. So, and it's really, it's almost the opposite. So with trademarks, they're giving you a monopoly on that brand. So they make it very difficult. It's very hard to get through that process. On copyrights, they want to encourage creativity. So the process is much simpler. I would still recommend working with an attorney, but if you want to try and DIY it, it's pretty forgiving if you make mistakes.
So what are some examples of things that people should get a copyright for?
So an online course or curriculum. I have seen people do keynotes. Podcasts are hard to do because it's episode by episode, and that's just a slog. It's a lot of work and time and money. Books for sure. And if you're working with a publisher, they may take care of that for you. They may not. That's something to check your contract on whose job that is, but definitely a book. I've registered the copyrights to entire websites, especially if they have a rich, history of blog posts or really good content.
Wow.
So again, the analysis is it valuable to your business? Would it impact you if it was copied?
That's fascinating. So again, everyone who's listening, courses, books.
Yeah, we register a lot of courses. Yes.
Yeah.
And
that's a lot.
The thing I will say though, kind of on the flip side of this, people often ask, how can I stop someone from copying my course? You can't actually stop someone. You can set yourself in a good position so that if and when it happens, you can take action. But I usually tell people, don't worry too much about it being copied. Go ahead and put some protections in place and then kind of put your blinders on. And, if you have a personal brand, that is one of the wonderful things about working in this industry is that people are usually coming to you because of your secret sauce.
That's right.
It's not just that they want to learn about Facebook ads or they want to learn how to garden or whatever the thing is that, you're teaching about. So it's very hard for a competitor to just copy your content and have any kind of impact.
Yeah. And I love that you said that because that is so true. It's like they could go learn this anywhere else. They're coming to you because they want to learn it from you.
Right.
Right. And I love that you said that. There's a time and a place to go, hey, let's be wise and protect the things that are valuable assets that make you money, that have meaning to you, that, whatever. But at the same token, remember, at the end of the day, they're coming to you because it's you. And
Right.
no, I love that. I think that's a really good checkpoint of not creating panic. And
Yes.
everyone who's like, oh my gosh.
It can be a huge energy drain. I'm sure you've seen this. And
Oh
it can
yeah.
be very distracting and very upsetting when you find that you've been copied. So it doesn't
Well,
feel good.
so on that note, so what do you do if you discover that you have, right? Like if somebody has copied your work, like what do you do? What should you do?
Yes. Yeah. So step one is always create a record. So think about if you had to go in front of Judge Judy, what would you show her to prove that you had been copied? So that may be screenshots, that may be, creating a fake account and, downloading stuff, like, whatever you have to do to gather that evidence so that you can prove if you, God forbid, if you have to. Or just so you can attach it to, if you have to send them a letter, because things change, websites change, and it's not because anybody's doing anything shady. We just change things a lot. So gather that evidence before you reach out to the person, before they know that they're on your radar, so that they can't just take it down. And then step two, once you've got all that collected and organized, depending on kind of how important it is and who it is, this may differ a little bit, but I like the idea of reaching out to the person before you involve lawyers and before you get really mean and strict about it. Especially if the person copying you is like a lot further behind you in business or is just starting. It is kind of hard to believe that people don't know better, but some people really don't know better. And so, I am a fan of giving them the benefit of the doubt, reaching out gently and saying, hey, I noticed this. I'm sure you didn't intend it. Would you mind taking it down? Or, please attribute it to me, like whatever in your eyes would make that feel okay. And I would say 99% of the time they're super embarrassed and they will comply right away. They'll either take it down, they'll apologize. And then that 1% of times, they may get their back up and say like, no, I created this, or they'll deny it. And sometimes it's obvious. Sometimes it's a little more of a gray area. Like they've copied your ideas, but they haven't copied your exact words. And that's where it becomes a little harder. But then sometimes we do have verbatim copying where they say, no, I'm not going to take it down. And that's when you probably want to get a lawyer involved. If it is something that is, again, valuable to you, because lawyers are expensive.
Yeah.
So not everything is worth, spending thousands of dollars on hiring a lawyer to help you with. But if it is something essential to your business, then that would be the next step to kind of ratchet things up. Is get a lawyer involved who can help you. Sometimes people can say things accidentally that they don't know could hurt them later, as they're trying to be nice and friendly.
Anything you say can and will be used
against you. Yes.
But I think that I love that, where it's like you don't have to go right to level 10 immediately, send a cease and desist. It's like, hey, make the person aware, ask them to take it down, make sure you take the proof. Then it's like there's a system of escalation.
Yeah. It's very rarely like jumping to a lawsuit.
Which is good because nobody really wins in a lawsuit. The only, we were in a lawsuit once trying to get our IP back, and the lawyers were really upfront, and they just said, I just want to be upfront with you. Day one, you do not win here. The only people who win here are your attorneys.
The lawyers, yes.
We just want you to know, even if we win, you're not winning. We're winning. Yes. And they were so correct. And I was so appreciative of like, oh yeah, like you won big time, because it's an emotional drain. It's a financial drain. It's a time drain. And it's like, you better really be sure. And also that should, on the other side, people don't want to be involved in that on the other side too.
Right.
So I love your approach of most people are going to be embarrassed and they're going to want to avoid that as well. So start with doing that before you involve attorneys. Now, I do have a personal question, and I'll leave any names out of it. But in my husband's first book, there's a very famous quote, right, that he uses in his speeches, in our courses. In the book, it's just kind of like one of those signature pull-out quotes. We call it the rent axiom, which is, the rent is always due. And people really like that and took
and
that.
This is his original, right? He didn't borrow it from anyone else.
Yeah. And they took it and used it and quoted it and put it on t-shirts and put it on posters, shared it on national television, and never cited it. Now, I believe that some of these very well-known famous people probably didn't know where it originally came from. They just heard it
Right.
from a whomever, from a whomever, from a whomever. So what do you do in those cases where you're like, hey, like you're saying this and not giving yourself credit, but taking credit for it? What do you do in those cases?
Yeah, I think again, you have to decide, like, is that impacting your business enough to spend the time and energy chasing it? And maybe it is. Maybe this is something that's really personal and means a lot to him and that he wants to be attributed. I mean, I think if you see like memes and quotes, they are misattributed all the time.
Totally.
And so you're definitely playing whack-a-mole at a certain point, trying to go after all the places that have, cited that incorrectly. But there may be a couple, if it's Oprah, that you try and get in touch with their people and like that's a big platform. I would like for this to be corrected.
Yeah.
And, especially if it's a news organization or something like that, where they do value correctness
Accuracy.
and yes, accuracy. They may issue a correction. Now, corrections are never
Helpful.
really, yeah, they are never
Right.
as prominent as the original thing.
Yeah, that's interesting. So
yeah.
you're kind of just SOL, kind of.
A little bit.
Yeah.
Again, we all have limited time and resources. So even though I'm a lawyer, like you could spend all of your time and energy chasing after this stuff. And most of the time it's not really having an impact on your business. So I'd rather see you focus on growing the business, being proactive.
Yeah. And I love that because what it is having an impact on is your banking account with all that money coming out.
Yes.
So back to be selective, be protective, but be selective. Right. I love that.
Yeah. Not every battle is one you have to fight.
Amen. I love that. So, okay. What else do we need to know to protect our brand?
Okay. This is the one that nobody talks about because trademarks and copyrights are sexier. But contracts are really the biggest, most important, like legal foundation. This is really, even though we're IP lawyers here at the AWB firm, we spend almost all day, every day working on contracts that may touch IP and may not. So tell me how you see contracts coming up with your clients. Like because I can think of a couple, but I'm curious what you see.
It's so interesting. I feel like most people wonder if they need them.
Oh.
And my response is yes.
Always.
Yes. If you're collecting money for services, yes, you probably want one. But I think a lot of people really struggle with how much the laws are changing and how to stay on top of it. Like, non-disparagement clauses are now illegal. Right now, there was that, bill that passed eliminating non-competes.
I was about to say, it's in flux.
Except for right executives for X amount of period. So there's these nuances to it. And if you don't live in the legal industry, which I do not, but I'm in the EO group with you, right? Entrepreneurs Organization. And that's just a really added bonus that people are always talking about these things. And I catch them really in the peripheral. But for those of you who don't, so like this is a great example with this new non-compete law. Does that mean that all of us as business owners need to go update all of our contracts today? Do we need to go and, have previous signed employment agreements refreshed? Like, what do these laws mean? It's one thing that they passed, but then what are we expected to do? And if we don't know because we're not attorneys and we do have them in there, and then someone's like, that's illegal. So I think those are the nuances where I hear, I'm like, well, I didn't know that.
It feels very overwhelming.
To know that? And so I think it's one, do I need a contract? But then two, it's like, what do I need in the contract? And I'll tell you the number one thing that I hear from at least our audience is, I don't want a 13-page contract. And I don't want it to sound like some attorney wrote it because no one can understand that junk. Like, how do I get a normal everyday language agreement that I can understand and my clients can understand? Yeah. And that's kind of hard to do.
It is. So going back to the first question, a contract is better than no contract, even if it's not perfect. So I will take an imperfect contract all day long. All the contract is doing is setting expectations between two people or two companies about what's going to happen, value that's being exchanged, if there's money being exchanged, services, if you're selling a course or a curriculum or licensing your content to somebody else to use. So there's still going to be a lot of good stuff in there, even if you mess up some of the specifics. So And most things will not go to court. So that's the good news. Most of the time you're negotiating with the other person if something goes wrong. So using a contract is better than not, even if it's not perfect. As far as keeping up with all of the changing things, I understand that is overwhelming. I have a resource to recommend, which is the AWB firm newsletter. So we send out a newsletter every week or so with these kinds of updates. So if you are in this industry, I can't promise we're going to cover every single thing. But it's a nice way to just get little, snippets about things that could impact your business. And you're not getting a bunch of junk that applies to like a giant corporation. It's really focused on online businesses.
I'm going to give you a plug for this because I subscribe to this. And the one that came out, I think last week was, are you mandatorily required to hand over sales recordings to your clients if they ask, right? And I literally sent that to our VP of sales. I'm like, I need you to listen to this. Right. And it's like, but it's like, those are like things that wasn't even on my radar. Right.
Yeah.
And it's like just subscribing to this newsletter. And just so you guys know, I'll put this in the show notes. I'll have all of the links for everything that you need and want and should do, even if you don't think you do. But this one, if you go to awbfirm.com/newsletter, awbfirm.com/newsletter, you can sign up for it. It's free. But like, this is a great example of like, this is like things that I'm busy doing other stuff with. I'm like,
right. You're not a lawyer. It's not your job.
Do we have to send these sales recordings and what are they going to do with it? So little things like that, I think are really, really valuable. Just a plug.
And the other thing I would mention is the way we approach legal protections and keeping up with all this stuff is proportional to the size of your business and to the risk of your business. So if you're just starting out, if you are getting your personal brand up and going, a lot of this stuff really doesn't matter because you don't have a lot of money in the business. You don't have a lot to lose if you mess something up. And you're unlikely to be a target, frankly, for someone to sue you, report you,
Bonus of being a beginner.
That's right. You're little business, little problems.
Yeah.
When you have a bigger business, you got bigger problems. And that's when you need to start paying attention to some of this more, which the good news is you have more resources to either hire an attorney, have someone on your team monitoring this kind of stuff so that you can make sure that you're compliant. Compliance matters more the bigger you get.
Yeah. And I think that's so wise. So on some of these specifics, like just because these are things that I know have come up in our community a lot, like non-disparagement, can't do it. So at the same time,
in some scenarios,
right? So tell me if you think this is right nor wrong. So one of the things that we did with our agreements is we said, yes, whatever, non-disparagements aren't, legal, fine, but you can't lie. Right. So we changed our clause not to, hey, you can't say anything negative about us. It's you cannot make false claims about us.
Yeah.
So is that in line? Is that okay?
Yes. And that was already illegal. Like that's libel or slander, saying things that are false. So what defamation clauses really if you have a defamation clause in a contract, what it prohibits is saying things that are true, but damaging or negative. So yes.
But that's, one of the things that's come up in my
it's a fine line.
One of the things that's come up in my EO group a lot is, well, their truth and the real truth are often different. How they feel versus what happened are different. So what is that gray area?
Yeah. So if you were going to sue someone for libel or slander for defamation, it can't be a feeling. It has to be a fact. So it has to be a false, statement that you could test or verify. And it has to have a negative impact on your business.
So let me give you an example.
Yeah.
This was something that came up in like one of the forum chat groups I'm in, and they took a screenshot and somebody had put on like Yelp or Google reviews or something. Worst business ever. Worst money I've ever spent. And it's like, really? Is it really the worst business ever of all time? Is that truly accurate? Is it really the worst money that you've spent? Really? It's like, have you eaten at, the gas station? I don't know. Like, right. It's like, really? Right. So what do you do with stuff like that?
I mean, that stuff is just part of being in business. you got to let it roll off your back. You can try and respond. I mean, I don't know about you. I've had some clients get canceled, and
Yeah,
it's often over
yeah,
like really silly things, and
yeah,
it's very painful. It's very hurtful.
awful.
But often the best advice is just to ignore it, like just to move on, go
Yeah.
do something positive to kind of shut out the negative noise. But I understand a lot of them are like, well, I want to sue them. And I'm like, that is
A waste of your time
kind
and
of
money.
kind of the worst thing you could possibly do, because now you're
It's just
amplifying
attention.
it.
It's just attention. It's
Yes.
just attention.
Yes. And I'll
So
often say this is not a legal problem. This is a PR problem.
yeah, that's
So
good.
some of it you have to kind of handle that way.
So what was the basis for getting rid of these non-disparagement clauses? Just,
They've been illegal for a while, but no one was talking about them.
yeah.
Um,
I don't know why it's like, this has been in the last 2 years and people,
it's been talked about more. So it's a Federal Trade Commission rule, and it's consumer protection. So it's meant to protect customers from being able to speak truthfully about their interactions with a business. So you can't, it's kind of like a gag on them being able to, which is why a lot of people want to include non-disparagement in their contracts with their customers. So it's still legal in other scenarios. It is becoming a little more iffy in the employment scenario, and I'm not an employment lawyer, so
yeah,
I'm not going to misspeak about that, but it is nuanced there. I do know.
yeah,
So if you are wanting to include a non-disparagement clause in a severance agreement or termination agreement, talk with your lawyer, because
first. Mhm.
yes, I'm not 100% up to date on that. But I know that in customer contracts, it has always, or not always, but it has for a while been not allowed.
But I think just everyone, as you're paying attention to that, just make sure that you are looking at your contracts to make sure they do say things that people are aware of. It's like, you cannot falsely exaggerate or make false claims. And I do contract reviews for some of our clients on occasion. Anyone listening, do not email me.
Do not send you my
I am not an attorney. You can email Autumn. She is. I am not.
We'd
But
be delighted to review your
like
contract.
in passing, like, hey, can you look at this? And it's like, and you don't have anything in there about cannot. And I think that's back to setting proper expectations of,
Yeah.
however common sense at things. Sometimes it's good to have common sense in writing. So that would be one. And then since you kind of like, this kind of came up for both of us, like this new non-compete bill that has passed,
Yes.
which will be nationwide.
Yeah. And so that is actually a regulation from the Department of Labor. So it's not a law, it's a regulation, but it has just come out. It has not been, they have a publication period where people can comment. So it has not gone into effect yet. And actually, we're sending out a client alert. I think it's like on my desk to review. So we'll be sending out a client alert. If you're an AWB firm client and listening, you'll get that. About kind of our recommendations, best practices. What we're recommending now generally is just start going through your files and checking to see if any of your agreements have a non-compete, so that whenever this shakes out, there's lawsuits being filed. We don't even know if it's going to be, in effect ever. So while that's all shaking out, we're not recommending any big changes yet. But just kind of like, this is a great time to just see if this even matters to you. If you're drafting new agreements, you might consider leaving it out because it may or may not be valid. One thing in the rules, it says if you include a non-compete after the rule goes into effect, or maybe if you have one, I can't remember exactly, but you have to actually send a notice to the person who signed that contract. Like, hey, that non-compete you signed is no longer valid. So I think most people don't want to have to do that.
Interesting. So what about
yeah.
pre-existing signed contracts? Those stand? It's just anything new.
No, the non-compete would not be enforceable.
But you wouldn't have to send out something to previously signed?
Yeah, don't quote me on this because it is detailed and nuanced, but read our client alert.
But that would be more like
we had a Slack conversation that was like very long about all the nuances. So it's not simple.
This is kind of back to the conversation at hand. It's like, what do you need to know? And if you don't know, how do you stay in the know, right? So that's my last question for today. Other than signing up for this newsletter as a very entry-level basic, have some sort of source of information. If people don't have an attorney on demand, or they don't have a legal counsel, or they don't, that's most people, right?
Yeah, so absolutely.
How on God's green earth are we supposed to stay up to date with this stuff?
You're going to do the best you can. And that is, again, proportional to the size of your business and the risk. This is something a lot of people start taking more seriously around. 500,000, 1 million, several million in revenue. So if you're there and you still are not really up to date on all this, like judgment-free zone, do not beat yourself up, but you can always do better tomorrow.
But do
And
something.
yeah, I mean, just the bigger your business gets, some of my clients come to us saying, I feel like I've got a target on my back now. And like, I've really got to make sure I'm all buttoned up, and that if somebody comes at me, that I'm like ready to go.
Yeah.
So you will hit a point in your business where it becomes more important. And I'm
And
not
you
saying
think
ignore it, but
once you're doing like 7 figures in annual revenue, would you say, hey,
you
like this is
definitely
when
need a lawyer.
Okay.
Yes.
So that's everyone who's listening.
I would say
consider
probably like
that.
500,000 to 1 million is that's a great entry point for us, because there's enough to do. You know, it's not just, oh, I need a contract and then we'll never hear from you again, because we love long-term relationships. We like to be kind of an essential part of the team.
You know, and I say this lovingly because we're friends, but not everyone really wants to pay attorneys. Like people don't
I
really want
understand. It is
attorneys.
not the most fun money to spend. I know.
But I think that's a good benchmark for everyone listening. It's like, even if
Yes.
it's, sometimes you just have to spend money even when you
And
don't want to.
put it in your budget. It's like, it
Mhm.
should be in your budget, just like marketing, or just like working with a bookkeeper or a CPA. Like, it really is a cost of doing business. You cannot ignore it.
And I would just say from our experiences, it's much cheaper when you're proactive. It's cheap.
Yes.
It's always cheaper when there isn't anything pending, right?
Mhm.
And it's cheaper to do on the front end.
For sure.
It's always easier and cheaper to do it when you do it right, right? And part of doing it right means that you've got the right protection in place and really the right education, which I think a lot of this is a lot of free legal counsel. So you can just,
Information, not
thank
advice.
you. That's right.
Well, and I'll plug one other
info.
thing. Yeah, I'll plug one other thing before we go, which is we have our own podcast, the Legal Roadmap Podcast, which I have stopped publishing new episodes, but there is a ton of evergreen content. So if you're looking for like the latest and greatest, it will not be there. But if you're looking to learn some basics about copyrights, trademarks, employment law, all these things that you need in a personal brand business, go check out the Legal Roadmap.
Yes, and we'll put that in the show notes as well. Autumn, this is so helpful, so knowledgeable and helpful, and y'all just all got at least $650 worth of free legal information. Not advice, just information.
That's right.
So thank you. This was so helpful. And again, I just want to do one more plug for the newsletter because I subscribe to it and it is super helpful. And I'm constantly telling people on our team, listen to this one, go watch this, like read this. It's awbfirm.com/newsletter. And then also, if you want to just stay in touch with Autumn, get additional tips, learn stuff, and also the AWB Firm, check them out on Instagram. AW Firm is their handle. Again, I'll put all of that in the show notes. And last but not least, check out the podcast, even though that they're not posting new episodes. You can go and get some evergreen content, which is the Legal Roadmap Podcast. Autumn, thank you so much. This was so helpful.
Thank you, AJ, for asking great questions. This was a fun conversation.
And for everybody else, check out the recap version that we will post shortly. We'll see you next time on The Influential Personal Brand. Bye, everybody.